Hi, everybody. My name is Charles Throckmorton. I'm a shareholder in the Miami office of Carlton Fields, joined today by my colleague, Aaron Weiss, also a shareholder in the firm's Miami office. And today we're going to talk about the Florida Telemarketing Act, which is the subject of recent amendments that are critically important. Aaron, let's start with just a basic background on what the act is.
Sure. So effective July 1st, 2021, the Florida Telemarketing Act will be amended. And this is basically the Florida version of the statute protecting against unwanted robocalls and robotext. The subject of unwanted robocalls and robotext, I may just say robocalls throughout our little session today, but that I'll cover robotext too, has been the subject of regulation both in Florida and on the federal level, as well as many other states, for 30 years. The big difference is almost all of the action, at least on the private enforcement civil level, over that 30-year period, has been under the federal statute called the Telephone Consumer Protection Act. And the main reason why that is because until these amendments, the Florida Telemarketing Act did not have a private cause of action. The amendments that will become effective July 1st, 2021, now add a private cause of action into that statute.
All right, Aaron, and so historically speaking, without a private right of action, how has the Florida Telemarketing Act been enforced?
Sure. So Florida law, in a nutshell, Florida has a whole bunch of statutes. I don't know how other states are, but in terms of the things that Florida regulates by statute, I think one day I pulled out the statute book and was just amazed by the scope of things regulated. You have regulations for stealing non-ferrous metals and adulterating syrup. But the common theme through Florida statutes is there's all kinds of statutes, but our person who stole aluminum pans, that there's no private cause of action for that. So just like the non-ferrous metal statute, you didn't have a private cause of action for violating the Florida Telemarketing Act. So that meant what limited enforcement of the statute that there would come from the local prosecutors or on a statewide level from the Florida Attorney General's office. What that really meant is the limited enforcement of that statute was really restricted to what people would probably call the really bad actors, the people engaging in what really appear to be outright schemes, as opposed to the real core violation itself is just making unsolicited calls. So a difference between what one may call an illegitimate business, a really nefarious business making unwanted robocalls, as opposed to a legitimate business who may even be a brand name business making unwanted robocalls. So that, as I said, the limited enforcement that there has been on the Florida state level had really been restricted to those really nefarious schemes as opposed to the more legitimate business. But with the private right of action and private plaintiff side lawyers having the ability now to enforce this statute, that will change. Absolutely will change.
Right, and so we're expecting some major changes as a result of the addition of a private right of action in the Florida Telemarketing Act. And the closest analog to that act is the Federal Telephone Consumer Protection Act, which you mentioned, the TCPA. Can you give just a brief summary of what the TCPA is, what it does?
Sure. So in 1991, Congress enacted the Telephone Consumer Protection Act. It's actually interesting. In the historical provenance of the TCPA, which was enacted in 91, one of the reasons why Congress said in the floor debates why they were enacting the statute is because they noticed that some states started having these statutes against unwanted robocalls, but some of the states didn't have private cause of action provided for. So that was one of the reasons why the federal TCPA went in effect. And TCPA went in effect in 1991. It was, got some action, but if you look at the cases brought under the statute, really for the first 20 years, it was, some, but not all that much. In 2011, the Supreme Court clarified that you could have federal jurisdiction for any TCPA cases. It was a federal statute, but there had been an open and debated question as to whether you could have the cases brought in federal court. And really, in the last 10 years, it's been the subject of an avalanche of litigation under that statute. And broadly speaking, the statute, the federal TCPA, it guards against unwanted robocalls, robofaxes for both unsolicited messages, and it could be both for marketing messages and sort of informational messages, which are a message you may get from somebody you do business with, but it may not necessarily be selling you something. And notice I didn't say text. The federal statute was enacted in 1991. Text messages were very new at the time. So text messages is generally acknowledged are covered by the TCPA, but that comes from case law and FCC interpretations. That is actually not specifically in the statute. So that may matter a little bit in certain parts of it, but the amendments to the Florida Telemarketing Act do specifically mention text messages. And
while we're still on the topic of the TCPA, a lot of people probably who will be listening to this podcast will be aware, at least to some degree, of the recent Facebook case coming out of the Supreme Court, which was issued in April, about 2 months ago. Can you give us an overview of that and the impact?
Sure. And this is really, the Supreme Court has seemed to have a TCPA case once every last few terms, including the last 2 terms. The one they had this term is really, probably the biggest deal ever in TCPA case law, or at least since the case they had 10 years ago when they said all these cases go to federal court. What the Supreme Court did in the Facebook versus DeGoid case is the Supreme Court settled a circuit split as to what is covered by the term automatic telephone dialing system. The federal TCPA has a specific statutory definition, and I'll sort of fast forward to the conclusion. The debate in TCPA case law centered around, on at least the auto dialing question, the open dispute over whether an auto dialing system covered by the federal TCPA was restricted to a machine that has the capacity to randomly or sequentially generate a number, or whether the statute also covered calling from a list. What do I mean by that? Well, let me give an example. Let's say that a bank wants to use robocalling technology, and use that term sort of loosely, robocalling technology, to call 10,000 customers for that day, everybody whose mortgage payment was due a week ago and they haven't made their payment, and the bank wants to load a list of numbers in and call all those numbers. That, under the federal statute, so these are numbers that exist. They're not being randomly generated. They're not sequentially generated. It's just a list of numbers. And that's really where a lot of the debate had been, is that list, was that a list calling covered by the statute or not? Well, what the Supreme Court said is that list calling basically was not covered by the statute. The potentially left open part of it, and this is what the footnote 7 people talk about from the Facebook decision, talks about whether merely having the capacity to randomly or sequentially generate a number is sufficient to be covered by the statute. So in other words, go back to my list hypothetical, you're loading the numbers in from a list. but the machine has the capacity to randomly or sequentially generate a number. So that sort of inchoate or unused capacity, does that cover the statute? And what does it mean to have the capacity? Does it have to be the present capacity? Can you load a new piece of software on from new code? So those are some of the open questions. The early returns on cases that have come out in a couple months since Facebook have, for the most part, although there's a new one that came out a couple days ago, which maybe went a different way, but cases seem to be taking the position that no, the calls have to be made from using the random or sequentially generated number technology. But that's the federal statute. We could probably go on and talk for hours about what the federal statute means. The big deal, and I think the most action for the Florida statute will be, is the Florida statute does not have that same or really any specific definition of what it means to be an automatic telephone dialing system. But it does say, and what's the exact language that Charles will read?
Yeah, so the amended Florida Telemarketing Act, and this is the key language where we think we'll see a lot of the legal fights once these cases start to be filed, is the definition of auto dialer is a lot more expansive than the TCPA definition as clarified by the Facebook case, etc. And the Florida statute amendment defines that as an automated system for the selection or dialing of telephone numbers or the playing of a recorded message when a connection is completed.
Right. So the recorded message, we could sort of leave that aside. The federal TCPA, that's really what a lot of the action on federal TCPA cases in the last few months have been, because of the doubts over the continued viability of most auto dialer claims. So leave that aside. The definition that Charles read is that doesn't tie back to, in the Florida statute, to the ability to randomly or sequentially generate numbers. So that's where a lot of the action under the state statute will be in the next, in the next many years, we predict. One of the other things is we also predict, at least in Florida, you will see federal TCPA claims brought side by side with Florida telemarketing claims, because if there's a doubt over whether the federal TCPA claim, at least under the auto dialing claim, is still viable, the potential to have the Florida claim would be stronger potentially under the statute when we see how the courts start construing it.
So, Aaron, what types of calls are covered by the Florida Telemarketing Act? So,
as I said, because there's not a ton of case law under the Florida Act, unlike the well-developed case law under the federal act, we can sort of just take some predictions and make some assumptions from what's in the statute. The core part of it is the federal statute covers both what we will call solicitation calls, where you're trying to sell something, and informational calls, where somebody is giving you information. Now, let me just put a pin in that and say that line has been the subject of extensive debate under the federal TCPA. And I just as a note, I keep on saying the federal TCPA. I'm just saying that to distinguish between the state statute, but the TCPA is the federal statute. So on that line, it really is a point that's generated quite a lot of spilled ink in opinions from judges and litigants trying to argue that a call is for the purpose of selling something. The plaintiff side will say no. Anytime a business communicates with somebody, they're ultimately trying to keep the customer in their good graces and eventually lead to a sale. And the business side perspective would say no, that the specific call at issue has to be what is specifically trying to say something. The difference is the Florida statute does not have a bar on sort of these informational messages. So the federal statute, the reason why it matters is because the level of consent needed for an informational call is not as restrictive as the level of consent needed for a solicitation call. Difference is in the Florida statute, the coverage really starts and stops with these the solicitation call. So I expect that much of the case law construing the federal TCPA on the distinction between what's a marketing call and what's an informational call will bleed over into how the courts start looking at whether a call is a solicitation call under the TCPA. But that's it. The language in the federal statute and the Florida statute is different. It's just the concept is the same. So that's where I think a lot of the action will be. But again, it's not a point where there's a great clear definition and a lot of open questions for courts and litigants to deal with in the coming years.
Right. And so I want to change gears just a little bit to talk about how we think that this will play out in lawsuits throughout Florida over the next several years. Obviously, with the TCPA, we have 30 years of precedent. We have 30 years of lawyers, litigants fighting about these issues all around the country. Definitions have been narrowed. Precedent has been set circuit by circuit. With this new statute and this expanded language, are we starting from scratch? Can we expect judges to rely to some degree on TCPA cases, or how do you expect that will play out?
Sure. So here's what I think will happen, and this is just a prediction. There is not a ton of state-level case law on the Florida Telemarketing Act, period. So in the early skirmishes, the cases will, I suspect, will rely on the analogous principles in the federal statute. We didn't talk, but we can talk now about where the cases will be filed, or where they will wind up. It's not a federal statute; it's a state statute. So, in order to have a case in federal court, there has to be a basis under federal diversity jurisdiction. What that means is in any one individual plaintiff would have to have at least $75,000 in controversy and be from a different state than the party making the call. And we didn't talk about the statutory penalties. Statutory penalties are $500 per call, and then the damages could be trebled. In the TCPA case law, before the federal statute went into place, most of the courts allowed defendants to remove cases or plaintiffs to establish federal jurisdiction based upon the $1,500 per call. So what that basically means is you could get federal jurisdiction with 75,000 divided by 1,500, which is 50. So to be in excess of 75,000. So if an individual plaintiff had 51 calls, that's what most of the prevailing case law going back to when you couldn't automatically get in federal court under the TCPA was. If you're in a class action, you get federal jurisdiction with what's called limited diversity, so it's not as difficult to get diversity, and you would have to have at least $5 million in controversy. So that works out to 3,333 or 34 calls get you above 5 million. So it's a little bit of an aside to how you get into federal court. So the short of it is you may wind up having a lot of these cases in federal court, in which case I would expect that federal courts, often some of the judges, the same judges who wrote a lot of these opinions, will look at their prior opinions and prior opinions from other judges in their courthouse on how they've construed this statute. For some reasons that go back a long way, including to a case that I lost about 8 years ago, the Middle District and Southern District became hotbeds for TCPA litigation over really the last decade. So there's a lot of case law from those two districts in particular on construing some of these concepts, at least.
And to the extent that state court judges or federal judges who find themselves with some of these cases before them are relying on TCPA decisions, you and I know we've litigated these cases in the 11th Circuit. The 11th Circuit has become, to a large degree, more defendant-friendly circuit, would you expect defendants under the Florida Telemarketing Act to be able to benefit from that? Or do you think it'll be more of a national review?
Some of them, I mean, the favorable cases that the 11th Circuit has come up with sort of favorable defense side cases. There's a case called the Salcedo case, which our team litigated, where the 11th Circuit said that you didn't have a plaintiff does not have automatic Article III standing for receiving a text message. Another 11th Circuit case called Gregorian, where the court affirmed, at least in an unpublished opinion, a decision from a district court judge saying that a plaintiff didn't have standing when they didn't hear a phone call ring. Those cases are largely Article III standing cases, and the contours of where Article III standing case in controversy, what that means in state court, those concepts aren't as clear. So we'll see. There's the plaintiff side can certainly find cases that they think are helpful and may help their cause on different concepts under the TCPA from the 11th Circuit and different district courts. So a lot of open questions.
Aaron, you mentioned earlier the potential impact of this more expansive auto dialer definition. What does that mean for example, a company that calls its customers off of a list?
So that's the big thing. So going back to my bank example, if under the Facebook decision, I don't think it's, companies making calls in that situation, I don't think would read the Facebook decision and jump up and down and say, yep, now it's open season and we could call everybody without any risk. But the Facebook decision, was generally held as at least significantly limiting the risk. Well, let's see what happens with the court decisions. What I could say for the Florida statute, without the restriction or without the tie to randomly or sequential generated number, there's less of a peg, and it does seem to contemplate that list-based calling likely will be covered by the statute. Now, look, that all remains to be seen what the courts say. I mean, the statute, it doesn't say, and this specifically includes calling off a list. As for instance, there were some proposals to amend the TCPA that did include things like calling off a list, but that's because the statute does not tie in or does not specifically mention or restrict it to random or capacity to randomly or sequentially generate numbers. We'll see what happens.
And Aaron, what should, two questions, maybe the last two. One, when do you anticipate that we're going to start seeing activity on this? And two, what should companies be doing or thinking about now?
So to answer your first question, I would expect that we will start seeing cases on July 1st. And I suspect we will start seeing a lot of cases quickly. I shouldn't say, I'm probably, it's a little bit of hyperbole. There has to be a little bit of time for the calls to be made. The statute, Florida statutes, unless they're specifically delineated as such, are generally not retroactive. But I really do suspect that within the next few weeks or months, or really once there starts to be a body of calls made, we're going to start to see just an absolute avalanche of cases under the statute. And what could companies do is get consent. I mean, that's really the best way to avoid liability under the TCPA has always been to make sure you're getting consent, and that will be the best way to eliminate risk under the Florida Act, now that there's a private cause of action. So that is, those are our thoughts. As I said, we'll probably do a follow-up in a few months after we see some of this action and what happens with these cases. If you have any questions or thoughts, you could find us on the website at carltonfields.com. We would be glad to discuss our thoughts on the Florida Telemarketing Act, the TCPA, or any other similar concepts with you. Thank you for listening.
Thank you.
This podcast is intended for general information and educational purposes only and should not be relied on as if it were advice about a particular fact situation. The distribution of this podcast is not intended to create, and receipt of it does not constitute an attorney-client relationship with Carlton Fields. To learn more about our cybersecurity and data privacy practice, visit carltonfields.com. Thanks for listening.